Expropriation. A property owner filed an action directly in court against the Republic of the Philippines for the payment of a parcel of land which the national government utilized for a road widening project. 1. Can the government invoke the doctrine of non-suability of the state? 2. In connection with the preceding question, can the property owner garnish public funds to satisfy his claim for payment? One. No, the government cannot invoke the doctrine of state immunity from suit. As held in Ministerio v. CFI of Cebu, when the government expropriates property for public use without paying just compensation, it cannot invoke its immunity from the suit. Otherwise, the right guaranteed in Section 9, Art. 3 of the 1987 Constitution that private property shall not be taken for public use without just compensation will be rendered nugatory. The doctrine of governmental immunity from suit cannot serve as an instrument for perpetrating an injustice on a citizen. If there were compliance with Section 9, Article 3 and observance of procedural regularity, the property owner would not have filed the action in court. 2. No, the owner cannot garnish public funds to satisfy his claim for payment. Section 7 of Act No. 3083 prohibits execution upon any judgment against the government. As held in Republic v. Villazur, the universal rule that where the state gives its consent to be sued by private parties either by general or special law, it may limit claimant's action only up the completion of proceedings anterior to the stage of execution, and that the power of court ends when the judgment is rendered, since government funds and properties may not be seized under writs of execution or garnishment to satisfy such judgments. Juan Casanova contracted Hansen's disease, leprosy, with open lesions. A law requires that lepers be isolated upon petition of the city health officer. The wife of Juan wrote a letter to the city health officer to have her formerly philandering husband confined in some isolated leprosarium. Juan challenged the constitutionality of the law as violating his liberty of abode. Will the suit prosper? No, the suit will not prosper. Section 6, Article 3 of the Constitution provides, "The liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court." The liberty of abode is subject to the police power of the state. Requiring the segregation of lepers is a valid exercise of police power. In Lorenzo v. Dr. of Health, the SC, held, judicial notice will be taken of the fact that leprosy is commonly believed to be an infectious disease tending to cause one afflicted with it to be shunned and excluded from society, and that compulsory segregation of lepers as a means of preventing the spread of the disease is supported by high scientific authority,